There were long lines at every polling station one could witness from the public roads across the country.
Mr. Irfan is walking into the polling station. Here he is. Any comments? Any comments?
As soon as I come out, I'll give you a comment. Thank you very much.
Across the river at Lenora, West Coast Demerara, the president's challenger, Irfan Ali of the PPP. While the media was allowed in to witness the president voting, there were no such arrangements for the media when Irfan Ali voted. However, that process also went smoothly.
Well, the process is a very simple process, and it went smoothly. I was able to cast my ballot.
Back in Georgetown, the Guyana Elections Commission GECOM was pleased at how the process started.
At the end of the day, all electors listed at all the polling stations.
The voting was without incident. The only problem is that there was a little plastic cap in the ink, and it took some time to remove it. But I have a slow hand. I am a patient person, so I did it. And everything went smoothly. The ballot paper had the correct names of the parties, and I expect that we'll have a smooth and successful process here today, Monday the 2nd of March.
We've been afforded an opportunity to exercise their function.
Moments later,
being rushed to the hospital from the GECOM Media Center at Hatfield and High Street, Georgetown. Mr. Mingo apparently has been sick since this morning. When the count for Region 4 was supposed to be continued at 9 a.m., it has now been delayed.
Moments later,
they're declaring a win for the afternoon without confirming. Region 4, this is fraud.
Shame on you, man. The devil's work.
This is unacceptable. They are attempting to declare the election without counting Region 4. We're here. They rigged all of this, and now they're declaring.
Every day come here, I avoid y'all. I know. You have problem with someone. You take it out. You can see. You
This is an embarrassment. Total embarrassment. Region, you cannot declare victory unless all ballots are counted. It has not been done. They have done everything they can. This is unacceptable.
We got it What are you gonna do? 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 God fight you. God fight you. God fight you. God fight you. Fight for a TRO. We can design anything, but the law provides whatever is the frame of our desire. You can't go out of the law to your personal desire. If you go out of the law to your personal desire, it's exercising bias.
And you say, don't worry about it, it's alright. You lie. You forget that the 10th of May
No, that is not a
was your girlfriend's birthday.
Mr. Lawrence
And she
was
said,
saying he
darling,
wants
it's
to
okay,
continue
I
with
don't
his
mind.
plan.
She
I
lied.
have no objection with that. You have
And
the
if a
argument,
woman
let's
going
continue.
out the door,
If you want, if
saying,
you
I am
want,
off to the
if
store,
the argument is
go buy
spoken,
one
we
item
move from
and
Georgetown
no
to the
more.
East Bank.
She lied.
Don't complete the
And if a man tell you, listen, mate, I
We
make
have to
love
complete this
7 hours
report.
straight.
We have to.
He lied, he lied, he lied. That's
We are committed to this process. We are committed to this process as long as it takes. We are not leaving the building.
No, the law doesn't
So,
say
sir,
specific.
the position here is that the position here, sir, is that we have a dialogue in place, that the law provides for it, continuous process.
These famous
It's
lies
not
have
based
been
on
going on
desire.
for many
It's not based on
years.
self.
You will hear them in Baltimore and in
A DRO, you said when you have a DRO, sir. You have a DRO, everybody has a list with all the DROs. You have a DRO, you appoint the DRO.
telling famous lies. Here are some that you
No, don't do
that mean? You know the guy called me. What you really doing to me? Don't worry about that. I just put the check in the mail. Listen. Your ex-wife in a party with a new man, lovey-dovey. And you say, we have a DRO in place. Please. The only issue here is that we have a DRO. We need a DRO. A DRO is in place. There is no handball. Let us continue the process. It is not based on desire. It is based on the law. And that is what we're asking for. For you to continue doing your job in accordance to the law, and let us have a DRO in place and continue this process. So please. That is what I came here to do, you know. Well, let's do it. No, but you listen to me, man. When you're telling me, take Dog, David, J, you go because they're here. You're not allowing it. No, he's asking for someone who's capable to take care of us. And if they are qualified and empowered by the I asked when I left here if Clinton go on TV and say Monica, not me. He lied.
And you said the guy from East Coast should come also. That was the final understanding that you left.
Listen to me in context. I said the East Coast. By in the morning, I said to both of you, we should be in the East Coast and we reflect. There's one question here. It's not can. The law provides the commission for us to use any.
I'm asking what is the impediment you see to using
almost
this person.
Everybody sooner or later
What is the impediment?
will tell you one of several famous lies.
I'm waiting for an answer. Don't
And you hear them almost every day. East, west, north, and south.
So you're leaving without
Let
that?
me illustrate what I'm
You're
talking
leaving without
about.
me gonna go.
What's this?
If a fella doing a scene,
This
or he buys
is
Penthouse magazine,
this is high-handed.
Okay guys, after the Mingo debacle and the High Court was brought into play, Chief Justice Roxanne Welcher ordered Mingo to use the SOPs, and we all know what happened there. He didn't use it. So the chairwoman decided on a recount. I don't want to add all those videos in because it's just going to make the overall video really large and long. So I want to get to the court cases that matters thereafter. All right, so let's see.
Guyanese, the Elections Commission has announced the date on which the total national recount of the ballots cast at the 2nd of March 2020 general and regional elections will begin. I welcome the Commission's announcement. The entire nation is awaiting the completion of the recount of the ballots and the declaration of the results by the Elections Commission. I have said repeatedly that I shall accept the declaration of the results by the Elections Commission, which will allow for a democratically elected government to be sworn into office. The general and regional elections were free, fair, and orderly. Subsequent events resulted in the prolongation of the electoral process well beyond the deadline for the declaration of results. That prolongation was occasioned by a delay owing to legal challenges in the Supreme Court of Judicature and the Court of Appeal. I have complied always with the rulings of the court. I have never intervened, or intruded in the work of the Elections Commission. Its independence is respected, and I have upheld always the Constitution of the Cooperative Republic of Guyana, which is the supreme law of the land. I await the declaration of the elections results. I had agreed on 15th of March that a total recount of the ballots from all electoral districts in regions 1 to 10 would take place urgently and in accordance with the Constitution, the applicable law, and the judgment of the court issued by Roxanne George, Chief Justice acting on Wednesday 11th March 2020. I had agreed also that a high-level team from the Caribbean community would be allowed to function only within the framework of the Constitution, under the aegis of the Commission and the rulings of the Court. CARICOM approved and arranged for a 5-member high-level team to travel to Guyana. The team was expected to observe the recount and submit its report to the chairman or heads of government of the Caribbean community. The team was unable to do so owing to the unresolved legal issues related to the national recount. The courts have since ruled. Guyanese, I am satisfied that the hurdles have been cleared for the Elections Commission to conduct the recount, and that the Commission Secretariat is fully prepared to execute its mandate. I am pleased to learn that the CARICOM high-level team has arrived in Guyana to observe the recount process in response to the Commission's request. The Elections Commission must be allowed to do its work in accordance with the Constitution. I urge all Guyanese to be patient as we await the outcome of the national recount.
Mr. Simon, there's a question which I would mind if you could help me with. 177.4 speaks about the validity of the election of a president. Who is the person about whom a question was being raised as to the validity of their election as president?
Now this seems like a very simple question to answer. Okay, let's hear what he says.
Well, to my mind, it was not the election of somebody as president, but the election of a president.
And who is that person?
Person should be
And who is that person? So, let's hear what he has to say here.
Whoever it's going to be eventually, sir. Because what the process in that section of 177 provides for, especially we look at 177B, if there are 2 or more presidential candidates, which one of them is going to be elected as president? So it is not, to my thinking, that one subsection 4 addresses a particular individual who has been elected.
It does not.
It does not, to my thinking.
So
it addresses the election process in respect of a president.
Just a minute, Mr. Simon. The Court of Appeal is, by that section, by that article, empowered to inquire into the validity of no one in particular.
You gotta love this judge. Alright, let's hear what he has to answer. So who exactly are they inquiring about? Which presidential candidate or which president? There we go.
Yes, well, yes, Your Honor.
I see.
That's how I read it.
Okay.
So it is towards assisting the process of the election of a particular person or someone who clearly would have to get more votes than the other candidates.
So when it goes on to speak about
president,
when it goes on to speak about the qualification of a person, if we don't know the identity of the person, how can we begin to assess the qualification of someone whom we don't know, who we can't identify?
With respect, I do not.
Okay, how do you assess the qualification of someone you don't know? Ooh. There we go.
Bring that is a proper way to look at it, because if we look at the section, what it says clearly, insofar as that question depends upon the qualification of any person for election. So the qualification of any person for election presumes that there is a particular candidate and one looks at the qualifications of that candidate.
Well, exactly. So what I'm asking.
This is absolutely painful to look at. All right, painful, but enjoy.
Is who is that candidate in this case?
In this particular case, which is before us, it would be either of the candidates. It is the election process to elect one of them as president, not any particular individual.
Well, you say either, but well, you tell me, how many lists were there?
Because we were aware that there were two.
I see.
And I do not think that can be questioned.
Yes, go ahead.
So that when we read the section, the validity of an election of a president, it doesn't say the president. It's not any particular person that it's referring to. And that is why I respectfully submit that it is the process of the election of a president.
And it doesn't say either a presidential candidate. It says a president.
It does say a president.
So doesn't it presume that there exists a president whose election, the validity of which is being questioned?
Mr. President, I think that would be giving it a very restrictive interpretation and meaning.
I see.
To limit it to that particular individual who is elected as president. So I would respectfully submit, especially as we're looking at the Constitution, that what we ought to be doing is giving it a liberal interpretation. Because what is important is that the process is followed, and more importantly, why the Constitution has provided that the decision by the Court of Appeal would be final and that the matter actually goes directly to the Court of Appeal is to ensure that in terms of time, that there is no wastage or there is no lengthy time frame for the court to meet.
Conceivably, this application could have been made the day before the elections.
Now this is where the justice is taking him into the realm of the ridiculous. And he has no choice but to try to justify the ridiculous. Enjoy.
I'm not too sure whether I would respectfully accept that. Because I am submitting that when we speak of the validity of an election, we're looking at the election process. So the process would have begun.
Doesn't the process begin with nomination, with the formulation of the list? Those things happen well before the election date.
That is indeed so. So that we're looking at the whole process.
So you can make your motion under 177.4 at any point during the course of the process.
Now this is where the justice is taking him into the realm of the ridiculous. And he has no choice but to try to justify the ridiculous. Enjoy.
Yes.
And so you could make your application the day before the election day.
Oh my gosh.
Yes, my love.
And
from
so
the time the candidate has been indicated,
nominated, put on the top.
Nominated, I think the election process begins.
And so the Court of Appeal would embark on this inquiry, and presumably they would stay the election date. Is that it? Until it determines the matter?
If that is reasonable, given the time frame within which the election, that motion has been filed, it may well be necessary so to do.
I see.
Oh my gosh.
Yes. Because if the court does not do that, it is possible that by the time the court gives a decision, the election process is completed. So if there is an urgency in respect of dealing with the matter prior to the full determination of the elections, then I think it would be within the discretion of the court to stay the election date. And I do not think that there is any legislation.
Moments later.
Okay guys, let me put some context here. Now, as we just saw, the CCJ just pretty much put a serious beating on the coalition and tell them to go back, declare the results of the recount, and get on with it. You know, we need to learn some English, and we just taught you English. But didn't end there. They found another relative of someone in the party somewhere to go file another bogus case to keep their nonsense alive. And we're going to see now the Chief Justice Roxanne Wilshire completely destroy them. And let's see if this stops them. But take a look.
On pages 26,
okay, guys. Of all the arguments we heard on the hearing in front of the Chief Justice, I think the two main arguments were done by the attorney for the chairman, retired Justice Claudette Singh, and the attorney for the CEO, Lowenfield, by attorney Boston, and for the GECOM chair, it was counsel Miss Light. So let's first listen to Miss Light, her argument, then we're going to see what Mr. Boston counters. Okay?
Dictate that your court is bound by the majority decision of the Court of Appeal. I therefore ask, Your Honor, why we are here again. It's a rhetorical question.
Now, Ms. Kite's first point of why are we here, because this was never challenged to the CCJ in the Ulita Moore, and it's the same thing being brought back. So it seems irrelevant and it should be dismissed right here, but she's just trying to make a point. But let's continue to listen.
Section 22. When there is a specific ruling that Section 22 can be best, the constitutionality of Section 22 can be best addressed during an election petition. And Your Honor, I find that that is the basis of most of the arguments proffered by Senior Jeremy. Those are the constitutionality of Section 22 is the platform upon which he bases all of his arguments. And Your Honor, that section has already been ruled upon, or the methodology to challenge the section has already been ruled upon by the Court of Appeal. And as I indicated, Your Honor, there has been absolutely no appeal from that decision. The second issue that we wish to address this afternoon, Your Honor, is the validity, as we have put it in our submission, in relation to Order 60. Much has been said, Your Honor, about the pronouncement in Eslin David's matter by our apex court. Your Honor, I first wish to ask this court, and I know this is a mature senior court, the entire judgment has to be read as a whole. To pick out or cherry pick certain parts, to misconstrue and base submissions on, Your Honor, I don't believe that this should be permitted. Your Honor, at paragraph 15 of the CCJ judgment, Reference there is made to the decision of the Court of Appeal and the specific findings made by Justice Reynolds that Order 60 created a new election regime. Your Honor, it was in response to that the court made certain specific findings, that it was trite law. In fact, it was elementary, the court said, that an order, subsidiary legislation, could not amend the Constitution. The court went further to say that GECOM nor the Court of Appeal could trample on the exclusive jurisdiction of the High Court to hear these matters. Your Honor, those observations were in direct response to the decision by the Court of Appeal to read Order 60 in a particular way as amending the Constitution. Your Honor, Article 8 of the Constitution also speaks to that. What Article 8 says, Your Honor, is that in any event, even if a subsidiary legislation or another piece of legislation comes into conflict with the Constitution, it will be void to the extent of its inconsistency. Not void ab initio, but void to the extent of its inconsistency.
Now, she's making an interesting point here that if something is if one aspect of a statute is deemed unconstitutional or inconsistent, then it doesn't completely vitiate or cancels the rest of it, and that's been ruled by the CCJ, and she's trying to make that point because the CEO and the APNU, they're trying to completely wipe out Order 60, and she's making an argument here which is supported by law, which has precedence actually. All right, let's watch.
And Your Honor, it is this time honored principle which the Apex Court was simply endorsing. I wish to make a further point, Your Honor. GECOM at no stage intended or set out to usurp, trample, trespass, or somehow take upon itself the clear provisions of Article 163 of the Constitution. That was never the intention of Order 60. Order 60, the purpose, the aim of Order 60 was simply to produce a final credible count of the votes of the March 2020 elections. How was that to be done? That was to be done in a clear, transparent manner, with all stakeholders present, with live streaming. Your Honor, a reading of David's judgment in the Apex Court shows clearly that Order 60 was endorsed by our highest court. The court references the procedure outlined in Order 60. And why that was necessary? That was necessary, Your Honor, because there were difficulties, there were controversies which visited the electoral process. And what the law says must happen. The very Constitution that my dear friend is relying on, 162.1 states clearly what GECOM must do when these issues arise. And it is out of that, Your Honor, that Section 22, therefore, becomes relevant. So GECOM, all GECOM did, Your Honor, was allow, or by virtue of Order 60, allow a credible recount of the votes to be done. GECOM did not invalidate any vote. GECOM doesn't have the capacity to do so. That is why we have the clear.
Now let's hear that very, very clearly. That GECOM does not have the capacity
or the ability to invalidate any votes. All right, let's keep listening.
Exclusive jurisdiction of the High Court, Your Honor, to deal with those issues.
Might I just ask a question though, Ms. Kine? You said it was never the intention, but I'm understanding from the applicant and others who support the applicant's case is that even if that was not the intention it was not the intention of GECOM in relation to Order 60, that in actuality there has been a breach. So they might not have intended it, but there has been a breach. That's my understanding of their case.
Yes, that is what they're saying, Your Honor. But nowhere in that order is there any provision. I mean, I've read this order and I know Your Honor has read it. There is any provision which establishes GECOM as the High Court to allow it to take evidence. It is not only an order would have to do that, we would have to amend the constitution of this country to permit GECOM to undertake that kind of evidence base to resolve, to resolve disputes in this manner. GECOM does not have the capacity. In no more, I believe, Your Honor, almost three times in Ali and David's matter, the CCJ reinforced this principle that the chairman of GECOM was correct in her determination that GECOM could not and does not have the mechanism to resolve these disputes, that the disputes would have to be resolved. Well, I should not call them disputes, the allegations, because at this stage, Your Honor, they are still allegations. The allegations would have to be resolved by virtue of an election petition. The highest court has already said that. So I know, my dear friends, their arguments are premised on the notion that somehow Order 60 is bad in law simply because the GECOM deferred and GECOM indicated that it could not resolve these disputes in the manner in which they were acting, and that really this would have to be resolved by the High Court. Your Honor, when you look at Order 60, where GECOM says that the order will resolve, or the recount process, Your Honor, will resolve and produce a final credible count, Your Honor, that is the counting of the ballots between what happened, which resulted in the March 13 declaration, and the recount. It was to resolve that, not for GECOM to take upon itself to become the High Court. Certainly, Your Honor, because as the Apex Court said, this would trespass on the exclusive jurisdiction conferred on the High Court under Article 163(1)(b). And the CCJ so found, Your Honor, at paragraph 52 of its judgment. To say, therefore, Your Honor, even if a court, I wish to say, Your Honor, even if a court finds that that small portion of the order was unconstitutional, Your Honor, that does not affect the entire order.
Sorry, what small portion of the order?
No, our submission is that it is not unconstitutional. I'm saying, Your Honor, that even if my friends premise their argument on the fact that GECOM somehow by this order is supposed to become an election court, I'm saying that when the time arises during an election petition, even if a court so finds that a part of Order 60 or a portion of Order 60 was unconstitutional, that does not produce a finding, Your Honor, that the entire order is bad and void ab initio. That is what I'm saying. Because all Article 8 says that anything which conflicts with the Constitution would have to be void to the extent of its inconsistency. So even if we go down the road of my friend's arguments, this does not invalidate Order 60.
But I'm trying to understand what portion you would be referring to.
Well, Your Honor, that is not our submissions. I'm just trying to clarify this. Because when you look at Order 60, Your Honor, no part of Order 60 sets out to make GECOM an election court.
Now, this is made very clear by counsel that no part of Order 60 sets out to make GECOM an election court. So they can't throw votes out, bring votes in, say this is valid votes, all the rubbish you hear from APNU. GECOM can't do that. All right? Okay, keep listening.
The final credible count which the order speaks to, Your Honor, is in relation to the count which led to the March 13 declaration and the controversies which visited. And so, as our apex court say, to ensure that this new transparent process would produce a final credible count. And Your Honor, 38 and 39. In fact, even if we start from 37 of the CCJ's decision, 37, 38, 39, 40, the court specifically, Your Honor, considered the transparent, credible process which resulted from Order 60. In our submissions, Your Honor, we have stated the process which Order 60 adopted and what different officers as a result were permitted to do as a result of that process. We rely, Your Honor, on those submissions. And we close, Your Honor, subject to the questions which the court may ask, if the court has any. We close with the fact, Your Honor, that, and our submissions bear this out, I've noticed that a number of the respondents they have also made this point. A number of these issues, I would say all of these issues, have already been litigated. They are just framed in a different manner, Your Honor. Neither can we just go with a contention that is a different party before the court. Your Honor, if we do that, if we say that because the party changes, you can come back with the same issue, our electoral process would never have finality. Because every time a court rules, a new party will come with an application. So, Your Honor, this is a simplistic view and manner to determine the issue of res judicata. Cannot rest on just that there is another party before the court. And I know Your Honor is a mature senior court. It has to do with what are the issues which are being ventilated. And I respectfully submit, Your Honor, that these issues, all of these issues, they have been ventilated either in Yolita Morris' matter or in Eslyn David's matter.
Good. Thank you very much, Ms. Kite. I just have a couple questions. I think Mr. Jeremy was making this distinction, and I had noted it, whether the Moore decision could be read narrowly to say, well, the court was really only considering the lawfulness of GECOM undertaking a recount supervised by another entity, to which we know CARICOM, as distinct from GECOM undertaking a recount, so that if the Moore decision is read very narrowly, is only speaking to the lawfulness of a recount, excuse me, supervised by CARICOM, as distinct from the lawfulness of a recount generally, that their pronouncements in relation to Section 22 and their pronouncements in relation to the recount being for any challenge to the recount being for an election petition would be, to use Mr. Jeremy's words, obiter, or not applicable to the case at bar.
Respectfully, Your Honor, I cannot agree with that narrow interpretation. when Yulita Moore, in her application, she was challenging the CARICOM supervised recount, and the declarations which she came for asked the court to order GECOM to accept the March 13th declarations, which is being asked for here also. May I just say that in passing? To order GECOM to accept the March 13th declarations. When the court, see, the finding of the court is what is relevant to you, Your Honor, because it is during that the court found that GECOM can conduct the recount. The court did not put any limits on the matter of that recount, except that GECOM could conduct it, and that GECOM, all that GECOM must do, GECOM must ensure that GECOM is not basically abdicating, ceding its functions to any other authority. So to now come to say that it was only in relation to that CARICOM recount, Your Honor, that is a very narrow and simplistic way to interpret the decision of the court.
And finally, either way, isn't the principle from Moore that if GECOM or the chairperson's decision can be reviewed by the court, that the chairperson GECOM's decisions can be reviewed by the court if it appears, either GECOM or the chair, they appear to have acted or be acting outside of their constitutional or statutory powers. Isn't Moore espousing a general principle that the court can exercise its supervisory jurisdiction?
Yes, please. That has been endorsed by Moore. The court said the only way that the court can intervene is if there seems to be, if GECOM is either acting in excessive jurisdiction, then of course the court can intervene in a supervisory manner. We have contended here, Your Honor, that when you take all the issues into consideration, that GECOM is not acting in excess of jurisdiction, because all GECOM is doing is attempting to bring closure to the electoral process after a valid, endorsed, transparent process. So we have addressed that in our submissions, and we have stated that, yes, if there is excessive jurisdiction, but here in these circumstances, Your Honor, GECOM is not acting in excessive jurisdiction.
Now here Boston is going to try to make an argument that the recount is legal and then the recount is not legal, you know, all in the same argument. So the first stage here is going to say the recount is okay. So watch.
If it is amending Section 84, then what act is it contravening?
No, if it amends 64 without replacing it, all it has done,
Boston, I'm sorry. If you say it amends, then it must replace it with something.
But
if it amends,
it has not replaced it. What it has done is to make Section 84 ineffectual, so GECOM can act unlawfully and recount votes that were deemed to be final. That is what it was doing.
Moments later.
So
Mr. Jeremy did not argue that alternative view.
Okay, so which view are you really supporting? Because, you know, is it Mr. Jeremy's view or your alternative view? I mean, I have to get guidance from you. And Mr. Jeremy is saying I should accept his view. You were saying you began, unless I misheard you, you began your submissions by saying Section 22 is constitutional, because that's why I stopped you and I asked to make sure that I was making a correct note.
Alternatively, the fact that I'm arguing alternatively does not mean that Mr. Jeremy has not adopted that alternative position.
Oh my gosh.
Oh dear, Mr. Boston, I don't know if you can speak to Mr. Jeremy, but I will hear him later on. But I don't know that he adopted your alternative position, but be that as it may.